a few people, just who we are and why you're interested. Ms. Fuller.
Oh, all right. Well, I'm Jean Fuller, and I'm the Assembly member from the 32nd District.
Good afternoon. I'm Scott Harvey, Chief Deputy Director at the Department of General Services. And one of my joys is serving on the State Allocation Board on behalf of our Director.
I'm Mary Clark, and I'm the court reporter.
The court reporter, okay. Hi.
I'm with DGS, and I'm doing the webcast.
Okay.
I'm Lyle Smoot. I work with the Facilities Division of the Los Angeles Unified School District. Obviously, we do a lot of coming before the board asking, begging for money.
Right.
I'm here with Senator Allen on the post office.
Richard Gonzalez and Associates.
Ian Padilla with Cash. Wayne Brooks. Right now with Murdoch Walrat Loans. For 14 years I was captain in New York. Sat on the board.
Uh-huh.
4 different states.
Okay. Institutional memory. All right. We need some of that. Oh, okay. Well, we got to tap a lot of people there.
Yeah, words of wisdom quick.
I'm Patty Herrera with Cash.
I'm Scott Burns. I'm a professional research parliamentarian, president of the California State Association of Parliamentarians.
Ah, great. Excellent. Thank you for being here.
Chris Long with Hancock Wilson Park.
Lisa Jones with Public School Construction.
Okay.
Bruce Hancock, Gunnison Park, and for 6 years I was the Assistant Executive Officer for the Allocation Board, and for 13. How many years? I can't remember, Lisa.
No.
For years, some years prior to that, I was in OPS.
Great.
Anna Ferreira with Murdoch Walrat Homes, representing the County School Facilities Consortium.
And I'm Lisa Kaplan. I'm the Assistant Executive Officer.
And
I'm Nathaniel. I'm the intern for the superintendent.
learning about government organization. So, welcome everyone. It is my hope that we can have a few short, focused meetings to develop some broadly agreed on rules and procedures for the State Allocation Board, and take up also some of the policy areas in which the lack of a stated regulation led to extended debate and difficulty in achieving resolution on the part of the board. It's been interesting to me that, for a while it wasn't even clear that we made motions and that things would be adopted and could be amended and move forward in a kind of really orderly way. So hopefully what I was actually thinking was that today, if we hear from both Mr. Burns and Mr. Schmidt about the two different sets of rules for conducting public business. One is Roberts, which is now the default model for the SAB. The other is Mason's, which is the default model, I think, for the Assembly. Yes, Jean, as well as the Senate. And Greg, who knows more about this than any of us, can talk about Mason's. But if we could really talk about what we might want to do in terms of getting one body and then direct Lisa to look over the draft rules here in light of either Roberts or Mason's, whichever we might think would be better, and make a decision on that, something that we could look at, mark up, and then just approve at our next meeting. And then I think we're going to need some other meetings to talk about such things as the process for setting the agenda, the binder, a number of us have talked informally, at least on the Senate side, about how to make the binder the most useful, focused document that we can really work from in an efficient manner. There are other issues such as the officers, how they're elected, the implementation committee. We once had a long session about appeals process for the board, which is really important because sometimes things go awry and districts don't agree with the decision that's been made, and whether or not to have what we're calling a mercy clause, which most classic one, the secretary has cancer and therefore doesn't get the revised application in on time. What constitutes mercy? Or a district turns down a bond 2 or 3 times. Does that constitute hardship? There are some things we just need to clarify so that we don't have to debate them every single time they come up. And this was under objectives and goals in your binder. I just wondered if members of the committee had anything they wanted to add to this. If not, why don't we get through?
I might be interested in just adding processing of the audience, how long the audience gets to talk, how do we decide when they're acknowledged, what is the criteria. I think my viewpoint on this, and Lonnie, the senator had to really twist my arm to be here, but she did, and I'm here, is that when I originally started in 2006 on the SAB board, we sort of operated a little differently, and of course we weren't as troubled at that time financially, so the situation was easier. Pretty much people were doing protocol that they'd done over and over, but there was no chaotic ambiguity around the issues that there is now. So the processing of the people in the audience was much, much faster. And so somehow, for me, that's my interest in this whole thing is, so if people come up, I don't want them to have to come up like 3 times or 10 times. I want to figure out a way where we process them pretty quickly with some, maybe it's school district rules, I don't know, but in the interim that everybody gets, and that then gives us some way to estimate how long the agenda should be in the first place when we're setting the agenda, because now we can't seem to estimate how long the agenda should be, so it's huge, and then legislators just can't give a 6-hour meeting month after month, and so the whole thing starts unraveling. So for me, it's not so much, it's a little bit about which set of rules is it, but for me it's a lot more about how did we get to the point where now we're just like a giant forum out there, and nobody really seems to understand what the policies and procedures are underneath that, and so we just endlessly debate in the forum, and we never get to deciding motions or processing sort of ends it for everybody for a time being.
Good. So I'm going to add public comment.
Thank you.
Public comment, because I know that city councils have really almost a legally established requirement for public comment. I don't know if that's part of Roberts. I don't know if it's Mason's does not have it. I don't think. But let's.
And one of the things
find
that
out.
I would like to make that as we go understand under the discussion tab, what the board can do is look at Roberts and look at Mason's and decide which one they want to be the default, and then create their own operating rules and procedures, and where issues are not addressed, it default is motion, but that they can add, specific to the state allocation board, that if you want public comment to be 3 minutes, that would be in the rules and procedures.
Right.
So
I'd like to remain open on the question as to whether or not one of those well-established processes or forms of conduct couldn't be ours. I mean, maybe we will decide that Roberts suits us just peachy keen, or that Mason's does, or it may be that we have to have a hybrid, given the nature of what we do. And if I can just segue into your very last comment, to me that is one of the most important things, which is resolving business so that we don't continue to continue. We have resolution and we move on. And the dicey issue around that, and I think it was in something Ms. Kaplan prepared, is what role, if any, should reconsideration play? And can we have a reconsideration process given what the Attorney General had to say about our ability to or not? But to me, it isn't just about moving paper. It's making sure people in a transparent way can see what we are doing, but that we actually do it. And we don't form shop. We don't continue items until there are 6 votes. We don't play those games. We move the agenda.
Hear, hear. Having established that, the first we were going to hear from Mr. Burns, just to quickly walk us through Roberts, and then from Greg Schmidt, our Senate parliamentarian, to do the same with Masons.
And for one moment. I'm not reading all these notes. It's one page I want to look at.
Okay.
Thank you again. I'm Scott Burns. I'm president of the California State Association of Parliamentarians. I work as a professional registered parliamentarian, which means I'm credentialed by the National Association of Parliamentarians. Sure. And then I'm also a member of the American Institute of Parliamentarians and the American Congress of Parliamentary Lawyers. Until shortly ago, I was also an attorney for the California Department of Transportation across the street.
Okay.
Just in case anybody hadn't seen it, I thought I should let you know that if you're trying to decide based upon heft, it's pretty much an equal decision. They're both thick books with a lot of details, and I know I've been asked here to speak primarily on Robert's Rules of Order, and in doing so, I want to distinguish a little bit about how it differs from Mason's, hopefully without stealing thunder from Mr. Schmidt. I sent in Ms. Kaplan a couple of write-ups that go into some detail, and so I don't want to go through all that detail before you hear again. You and staff have a chance to look at those later. I'm more interested in kind of a conceptual difference between the two authorities. The Roberts was first developed a little over 100 years ago as an adaptation of the rules for the U.S. Senate and House of Representatives, because there was a lot of disagreement as to exactly what parliamentary procedure was and what it should be for organizations that were not legislative bodies, religious organizations, nonprofit organizations. And so Henry Robert tried to come up with essentially a codification of what was then the common law of parliamentary procedure and the Senate and House rules to try to come up with something that would be an adaptation that could be used by ordinary societies. Mason's, on the other hand, was developed in California, and the Senate is now published by the National Conference of State Legislatures and is intended more for legislative bodies. And there's a distinct difference in philosophy between the two authorities. Roberts, I should mention, first of all, is not the only parliamentary authority. I brought a copy of the Standard Code of Parliamentary Procedure, which is published by the American Institute of Parliamentarians, and is thinner and is essentially an attempt to bring Roberts a little more up-to-date, less arcane, less archaic language, eliminating some of the more confusing, obsolete forms, but essentially the same general principles. In any event, there's a philosophical difference, and that is that Roberts is focused on member-driven organizations. So one of the reasons Roberts is so thick is because of issues that have arisen in member-driven organizations over the past 100 years that needed an answer. And so Roberts is intended to be a fully authoritative resource for whatever's come up. Mason is somewhat similar, but with the special needs for legislative bodies. And if I were to say the biggest difference between the two is that Robert is very concerned with membership organizations, where one of the principal things you have to be worried about are the rights of people who aren't there. Okay, we're going to have a meeting of a club with 1,000 members, only 100 show up, but the people who aren't there have rights as well, whether it's a motion that's going to be adopted or amending the bylaws or whatever. So Roberts has protections built in, things requiring prior notice, higher vote threshold, 2/3 votes for certain things, previous notice of certain actions. Mason is, because it's dealing with legislative bodies and predominantly, and recognizing that legislators essentially are working as representatives, but you can't have an artificial restriction on a legislator's ability to take certain actions for the benefit of his constituents merely because somebody didn't show up at a meeting or because someone else didn't get proper notice. So there's a bit of a different philosophy between the two authorities. Some examples. Under Mason's, a failure to abide by the rules doesn't invalidate an action. The majority is always in control. So under Mason's, even though you've got an authoritative rule book, and you, as Ms. Kaplan suggested, you're always going to supplement with your own rules no matter what authority you establish. Under Mason's, if you violate your rules, the action may still, as long as the action taken is fair, just, equitable, and proper, not a result of fraud, it's a legitimate action. Under Roberts, your rules have to be followed. And there is a motion you can suspend the rules, but if you violate your rules, depending upon the circumstances, it can invalidate the action. Under Mason, the majority is always in control. Okay? Everything is a majority vote. Under Roberts, there are some things that require a 2/3 vote, again, to protect the rights of either minorities who are present or individuals. So, for example, if you want to cut off debate, it's a 2/3 vote in Roberts, it's a majority vote in Mason's. Even in Mason's, even if you have something that requires a 2/3 vote, Mason allows you to change that rule by a majority vote. So really, Mason's is, the majority is in control. And again, it's recognition. I believe one of the members here said, you've got legislators who are together, need to get business done. We're going to get business done, and if a majority is willing to move on it, we're going to move on it. We're not going to allow a minority to control. Rules of debate are a little bit different. Under Mason's, a strict reading of Mason's, every member gets to speak one time and one time only on an issue. By custom and practice, typically may be able to speak a second time on an issue, particularly if something needs to be clarified. Under Roberts, each member gets 2 times. Roberts allows up to 10 minutes per speaker, although again, most organizations adopt a 2 or 3 minute rule. Mason's doesn't actually have a time limit, but again, most organizations have a rule. In Roberts, typically motions need to be seconded. In Mason's, they don't. So any member is free to make a motion. Again, in Roberts, 2/3 vote for most things. Majority vote for most things, but 2/3 for some. In Mason's, it's typically always a majority vote. I heard concern registered about reconsidering. They're both somewhat similar in that in order to move to reconsider something, it typically the motion has to be made by someone who voted on the prevailing side. Roberts is a little more in a committee structure. It says anyone who didn't vote on the losing side. So Roberts allows a motion to reconsider by someone who wasn't present or who abstained from voting. That said, the big criticism about Roberts is that it is an authoritative work. As a professional parliamentarian, I'm often called in to rescue groups who adopted Roberts as their parliamentary authority because they wanted to have a procedure for making motions, seconding, voting, and then a dispute arises, or a legal dispute arises, and they discover that because it's their parliamentary authority, they're bound by something in the back of the book that they never read or never knew existed, and all of a sudden they violated some rule. which is why I suggest that no matter which authority you ultimately go with, you're going to want to adopt some special rules to make things work more efficiently for you. I would never recommend someone adopt any parliamentary authority and just use it. One of the advantages of Masons for a body such as yours is that obviously it is the legislative authority for your assembly members and senators. So at least for veterans, they're probably familiar with the procedure. First termers may get a little bit confused by it. Roberts, on the other hand, is the predominant parliamentary authority in the country right now. About 80% of organizations use it. So many of the people that come before you, whether they be school boards or others, are probably using Roberts, at least at the basic level. So they're a little more familiar with it. To a certain extent, I think your decision may be somewhat academic. And the reason I say that is because all of the complication in Roberts comes from its procedures. You remember, Roberts is designed for primarily for large organizations, religious bodies, conventions, labor unions, professional associations, nonprofits. And so it's got a lot of procedures for, how do you, to keep things orderly when you have anywhere from 60 to 60,000 people together in a room. It also, however, expressly says that when you've got a small board or committee consisting of 12 members or less, then informality is the rule. And you only fall back on the more complicated rules if the process breaks down. So, for example, and I've got this in one of my handouts, under the formal procedure of Roberts, the presiding officer sits back, facilitates the meeting, but doesn't participate in the proceedings. Okay? Under the committee rules, the presiding officer is a fully participating member, makes motions, is allowed to vote, allowed to debate. In the formal procedure, all motions have to be seconded. In committee procedures, no motions need to be seconded. So the second does not exist. In the committee structure and small board structure, the rules on debate go out the window. So there is no limit on the number of times anybody can speak, and there is no motion to close debate. You continue debating until the group decides it's ready to move on, and again, essentially by consensus or majority vote. So while there are many differences between Roberts and some of the other parliamentary authorities for larger groups, I think for a group of your size, it's really almost the complications of Roberts go out the door, and it really gets down to the philosophical differences. Do we want an authority that allows majority vote as the plain and simple rule no matter what we're doing, or do we want a rule that has a higher vote threshold for certain things? Do we want something, for example, Roberts has, I think, 26 pages on the rule for reconsideration. Whether a motion can be reconsidered depends upon when it was made, who made it, who wants to reconsider it, how much time has elapsed, whether it can still be renewed or not, and whether it's a procedural substantive motion or privileged motion. Okay. If I were to go to the standard code, for example, it's very simple. Anybody can move to reconsider at any time, period.
Okay, I think we should probably...
You're right. And with that, I think I've pretty much said everything I needed to say. And if there are any questions now or later, I'll be in the room until you're done.
Right. Thank you very,
Thank you.
very much.
Thank you, Mr. Bennett.
Right. Yeah. Mr. Schmidt?
Well, bless his heart, he did manage to cover a lot of the points that I was varying nature. But it occurred to me when I was listening to that perhaps you're looking at the wrong form when you discuss either Roberts or Masons. Though Masons is kind of an document for the conduct of business in the legislature. And in fact, 99.9% of the business in the legislature falls under the respective rules of the House. And there are many elements of Masons which we may refer to periodically, but in fact we rarely use Masons for any determinative purpose in the course of any given day. Masons is a compendium and an attempt to bring some order out of chaos in putting together very disparate parts of legislative procedure from throughout the country It was done by a fellow who was the Assistant Secretary of the Senate, Paul Mason. We're proud that we handed it over to the NCSL because we don't have to take care of it anymore. But in fact, we really don't use it very often, and at least as far as the Senate goes, the rules and usages of the Senate ultimately can be considered prevailing when there's a conflict between what we've done historically and what Mason suggests we do. So I think it would the decision that you would make about what rule format you use, if I were in your position, I would kind of be concerned about what is it that I'm voting on and trying to deal with on a regular basis. It's not making decisions about whether you're going to participate in the parade or put in a float or anything. And they're specifically kind of legislative decisions. They're the kind of decisions I think that you would make in a subcommittee of the Budget Committee. And so perhaps what you really should look at are the rules of the Assembly and the Senate, and then see if those can provide some sort of a basic format for your decision-making process, expanded as necessary for the kinds of things that you do that maybe are different from the legislative process. As was stated, I mean, Roberts is an organizational rule manual. Mason's is a legislative rule manual. So it kind of depends on whether you think you're a legislative body, which I presume in a sense you are, or not. And that would be my suggestion, is to take a look at the
May I
House
ask, do you have
rules.
any advice as to what we are? I've heard us referred to as legislative, administrative, quasi-judicial. And we probably at any one time are all of those things. But given the fact that we are created in statute, and given what your prior speaker had to say about what I perceive as the informality and the advantages thereof, do you have any comments about that as a process where things are done by majority and you don't need to second and you can reconsider at any time? And, I mean, does that facilitate moving an agenda, or does that keep it open-ended?
Well, there's kind of two different ways. The way that we perform on the floor of the legislature is one thing, and then the way that you perform in your subcommittee or committee here may be more analogous to the way that legislative committees work. And there are some specific sets of rules as to how you move business along in committees. But also, successful chairs and members of committees know that the agenda moves along if you have a good chair, if you're courteous, if you're respectful of the people that fly up all the way from LA to talk, that you provide them sufficient amount of time to make their point, and that you still are managed to move the agenda along. So again, I don't know how to characterize what you do, because I've never sat in a state allocation board meeting. I'll give you my seat for a meeting.
From the building.
I presume you hand out money. Is that
We have bond authority, and yes, we try to anyway.
And to me, that's kind of a legislative act, but then that's my bias, but that's what I do. But, I mean, a lot of this is resolved by common sense and decency and courtesy. And nonetheless, I would take a look at committee procedures within the legislature to see if they're applicable for this kinds of things.
I think that's actually a very good suggestion, because, what we do in both the Assembly and the Senate is the presentation of the issue, speakers in favor, speakers opposed, and then you have to have a motion, except we are not allowed in the legislature to amend on the floor. You have to take the amendment in the next committee or several days in advance. And I think the State Allocation Board would find that very cumbersome, meeting once a month. So that's why, for me, Roberts, which it always seems like it's grammatical, it's like learning to parse a sentence in the 8th grade. I mean, because there's a way you make a motion, it gets seconded. If somebody doesn't like that motion, they can amend the motion.
Or substitute.
Or do a substitute motion, and it becomes clear instead of a sort of endless discussion, which we don't get into in the legislature at all, but we do in the SAB, which is why I think getting clear staff recommendations and then having a motion on that, but yes, having the ability to amend.
Well, you can amend in a committee setting. We have
Yeah.
some specific things we
It's-
require for you to amend in committees. I mean, like you have to bring written amendments.
Right.
And you don't do
Right.
graphic amendments.
Right.
But you could make that accommodation if you choose to.
Well, my experience at the SAB would be that it's actually easier to make amendments on the floor because you hear from the different districts, you hear from the staff. What do you think?
You know, I think I want to go. I love all this discussion. I think this is thoughtful, but I want to go back to sort of the end. One of the things that Scott brought up is, okay, so at the end of the day, who's the final arbitrator? You know, like we're going to pick a model here, but it's not going to be the final arbitrator. I mean, the final arbitrator is going to be whom? And in the case with the legislative floor, what I find to be most helpful, even though I'm much better grounded after being a superintendent for 17 years in Robert's Rules of Order than I am in Mason's. I'm still the new guy, kind of learning my way around it. What I find is that everybody that comes in to the legislature is willing to agree that Wilson or you are the final arbitrator. And so when we get into it, somebody passes a little note up to you guys and you tell us what it is and and that's it, we're done. In our situation, the uncertainty that has come out of the chaos of the financial controls being different than they were like my first 4 years have led to the fact that we never have a final arbitrator. We're now down to questioning which rules do we have even. In my first 4 years, we never questioned those rules, and we never questioned who the final arbitrator is. Now we're asking, well, if our own attorney tells us which rules we can have or we can't have, and that's what Lucinda and I both really agree on. Yeah. We want to know who is that final arbitrator, because I don't think we really agreed that was the person that was the final arbitrator, and that's what kind of brought this question. So for me, the which comes first, chicken or the eggs question here is what is it that we can lawfully accept as the final arbitrator, and that every legislator would be lawfully bound to, and then work from that premise. And then if I were to define myself on this board, 90% of what I've done is appeals work.
Yeah.
You know, this is an appeals board. This is very much like when you have a development, at least for me, you have a development and you have this little board, and then everybody comes and they don't like the way they've been taxed for some reason or another, and it's an appeals process. And it stems all the way from, needing mercy to, the rule doesn't exactly fit the circumstance. And in the first 4 years, the implementation committee worked really, really well, because the mediation process in the implementation committee was well honed and well received. And so by the time those appeals came to those of us on the board, it was a real bipartisan approach. I mean, it was pretty simple. The question was stated to us in a way that we were just focused on the question. We weren't focused on everything else. In the last year and a half, I've been increasingly frustrated that the questions that have been posed to us have been the everything else, and it's so occluding of the everything else that even I, who sat on a board for 17 years, and the senators sat on one even, maybe not longer, I know that would be kind, but probably has been longer, have not been able to devolve what the question is that we should be doing. So then if we go to a committee meeting format, which I like that idea, where I'm not exactly sure it's fair to the staff, but if the staff says, okay, this is what you ought to do, and then the appeals people say this is what you ought to do, and then there's some clarifying rule in the middle that's a criteria that we base it on, that Lisa has provided for us or whomever, then maybe we could come to some appeals precedents that would not break new legislation, because I don't think that's what we're there for, but would give us a judicial review for that unique circumstance. And I think that's what's not been happening, because the first 4 years we didn't have that many unique circumstances. You go 4 years and you maybe have like one unique circumstance.
You didn't have appeals.
Well, we did have appeals.
Oh,
it's just
okay.
that A, there was always bond money, B, there was always a list, C, everybody pretty much knew where they were on the list because they'd been on the list forever through a couple of different board configurations. And anybody who had a problem, we sent them back to the implementation board, and the implementation committee knew that they had to straighten it out there, because when they came back, we were going to stand behind what the implementation and the staff decided. That was what was going to be. Now it's like nobody really figures out what happened anywhere along the way, and it comes back, and so we just start making up rules, and then we don't know who the final arbitrator is, so we just keep making them up to our satisfaction based on who's there and who's not. And I think that's where the senator has a really good point, is she wants something that sticks. And so using a rule that makes it stick, it seems logical. For me, I don't think legislators are going to abide by rule. I haven't really seen that work too well in the legislature. I'm a little challenged. I'm a little challenged until I know who it's going to be that's going to be the final arbitrator, and then the rules are fine with me. I don't. It doesn't matter to me.
Well, now let's just take that, because I added that to the list, Jean, down here with public comment.
Who's the final
Because
know-it-all
it is true.
person?
In the legislature, it is Dotson and you.
And traditionally, that's the way we resolve things, though. In fact, there's another step past that, and that's if people disagree with the ruling of the parliamentarian, you can go to the respective rules committees.
Of the Rules Committee? Okay, now in Roberts, as I remember it from local government, the presiding officer essentially interprets Roberts, and you can't overrule the chair. There's always a motion to overrule the chair.
The appeal of the decision of the chair and a majority would decide.
Right.
So it's the board itself. But then when it comes to like the question of like well, reconsider, for example, there's a guiding rule sequence that's already in there. If you violate, if I understood what you said, and I'm not, if you violate whatever your rule is that you have in Roberts, then you invalidate the action. Whereas in Mason's, all you basically do is restate it until a majority of it, majority vote wins whatever it is. Am I stating that correctly?
I may have misstated that. There are some rules that can validate an action.
Sorry.
Yeah, we can have pull up a chair.
Yeah,
Greg, you could stay too, because we need to see.
Both of you.
Yeah.
But let me just make a comment first. I think both of you made the point that what we might be choosing now is it's a default model. So like what we have here in the back of the book is a proposed set of rules with, at the very end of the rules, do we default to Roberts or default to Masons? And maybe, as we have this discussion today,
Hybrid,
we could indicate in which ways we like either Masons or Roberts better, and then Lisa can do up another draft, putting in some of those modifications that, frankly, I would be very grateful if you guys would just look at those drafts, and if you see something that your experience tells you isn't going to work, let us know. Yeah, something.
Very quickly, just I didn't mean to lead you astray. In Roberts, the only rule that's really going to cause you any problem with possibly invalidating an action is a failure to give prior notice of things when prior notice is required. I'm assuming as a state board, you're probably governed by Bagley-Keene or something similar,
Yeah.
and so Roberts really isn't going to be a factor for that. You've got your statutory requirements for notice. So in Roberts, if there's a procedural error, any member can call for a point of order, but a point of order has to be timely, and if the point of order isn't timely, you just move on. The only time it would be a problem...
A point of order is not reconsideration.
Point of order is not reconsideration, no.
Right.
Point of order is just you're alleging the rules are being violated, right?
Clearly a difference. Right.
So just a very quick example. If you had rules for reconsideration and you're reconsidering something that you shouldn't be, under Roberts, unless someone rises to a point of order and points out your error in procedure now, the fact that you did it incorrectly is immaterial because no timely point of order was raised.
So really, you can really almost always in Roberts redo a motion if you
right.
If what's criteria are present.
Right. If I could paraphrase it, Roberts almost works on almost like a no harm, no foul. If the rules are being violated, but nobody cares, things are moving along, you just continue moving along.
Okay, but if
But
somebody
if somebody cares and raises an objection, an appeal, a point of order, then your presiding officer has to deal with that point of order. Yes, you're correct, or you're incorrect, subject to being overruled by the body if the body disagrees.
Technically, that's the same under Masons. There's lots of rules we have in the legislature that are not self-effectuating. So they're not really invoked until someone notices, for example, the lack of a quorum or all those kinds of, the biggest issues we have in the legislature are committee voting problems because people leave.
We have that problem too. We'll get there next.
People leave or they want to, open the roll and then continue the debate, close the roll again, all those kinds of things.
Okay, and maybe we should just look at that for a second. What about the issue of a quorum? Is there any difference in Masons and Roberts? And if a quorum is established, well, first of all, can you do business before a quorum is established? And second of all, if you lose the quorum during the meeting, can you put things on call, or can you pass things with a majority present and voting? Because I think we've had some issues around that.
Yeah, because in the first 4 years, we did not hold the roll open, I don't believe. I can't remember even once. But the difference was we rarely ever went for more than an hour. So everybody kind of knew they had to go and be there. And, your staff would call you if there was, an issue that you really want to vote on. If it didn't, we sort of trusted each other enough, because we'd all been there for a really long time, that it was going to work itself out. I mean, that's some of the things I can say. Now, between having the meetings down here where you just can't run down here fast enough to do it, and having them go, as soon as it goes over 2 hours, it's just a mess, and you don't really know how long before people are going to terminate their testimony, because they can keep getting out of the audience and walking up, sitting in front of the podium, sort of as long as they want to do that. We have kind of went to the last couple meetings, sort of our own hold the roll open if somebody asks, and then it got to be we'll hold the roll open if somebody calls from the next county, and now we're a little up in the air again on that.
You mean in terms of public comment?
Well, remember, we decided not to vote one of the last times until another member's committee finished over there, and we didn't know when that was going to be, and some of the rest of us wanted to leave, and we have the additional complication of 6. If you don't have 6, what is it?
Yeah, 6 members constitute a majority.
Yeah, if you don't have 6 members, then the whole thing fails. So if you're sitting there waiting to vote, and you leave, and then that person doesn't come until much later, but there's now not enough people there, then you have to keep bringing it up over and over and over and get 6 votes. So we either have to change that 6 rule, or we can't hold the roll open, in my mind.
Well, and my one question, maybe Lisa, I don't believe we, or the State Allocation Board as a body, can change the 6 is majority.
Then somehow we need, whatever name we call the rules that we adopt, and I don't care, we need to meet that constraint head on, because I think it's going to be a while before our meetings get short enough for us to go back to not holding the roll open, because there's 6 that are legislative
And one of the things what I did was take on quorum and voting, which is in the draft. I did kind of a hybrid of that 6 constitutes a quorum if a motion is made by 6 and then people leave. You can have the roll call stay open for other people to add on. If it falls below 5 people are at the meeting can still occur, but nobody can make a motion on any item, because it does take 6 of a quorum at the State Allocation Board to do anything.
So then for example, let's say you vote something, you hold it open for the 7th person. The 7th person comes and wants to reopen it, and one of the original 6 is now gone. In regular law, all the people who voted on it in the first place would have to be there, or you couldn't change it. Does that make sense? So, and we're going to have that problem of people coming
it's
and
what
going.
you can also do is like a hybrid, kind of like as it's done on the floor. If it's an item opens and there's 6 people there, and it's a 4-2 vote, you can't close the item, because to close it means it fails, and if there's only 6 people there, you have to wait until the others, and then they vote on it, and whatever it ends up that gets 6 votes. However, if the first roll call was opened and it was a 6-0 vote, that can close and that action item passes, and we can write it, basically, if it's a 6-0, no one board member can be the one that changes it to fail, like on the floor.
So basically, it's a Mason's, as we know it, a Mason's rule.
The Mason's rule.
Yeah, okay. And maybe for the sake of clarity, we should say, call it by the name that we know it, that rule, and then the model is a hybrid. Honestly, I have a little bias about doing a hybrid model for the SAB, as long as I've been here 4 years. We've changed people so much. Yeah. And by the way, I will be leaving soon because I'm going over to the Senate, and there won't be a seat for me. So I think this open door revolving thing continues to happen. So I'm very, very nervous about having a hybrid of rules that there isn't one person. I mean, I would really rather say it's either one or the other, and here's the arbitrator, and that arbitrator is going to be around for a long, long time, than the other. But at the end of the day, if we just can't make that work because of the new circumstances, then maybe we call it the hybrid model, and then I believe we're going to have a training for the whole SAB board, and maybe a manual or something to hand out after that, after we adopt it, in order to not create new confusion over a hybrid model. Does that make sense?
Well,
except that what I'm hearing is that we have a hybrid model now with Masons as default. Do we? Or not necessarily a hybrid, but we have rules of the Senate and the Assembly.
Those are specific legislative rules that have been adopted. I mean, we have limitations, for example, on reconsideration. You can go to less.
Right.
Those are specific House rules that aren't
by
necessarily
hybrid,
Masonic.
Yeah, by hybrid I mean putting some of Roberts and some of Mason's together, or making up our own combinations. By non-hybrid, I would be saying that it's one whole all Masons, or it's one whole all Roberts, whichever. And I don't care. I'm not so much about the default is one, but once you get into that mode, that's the whole thing. You don't have some special SAB clause for a certain case within that model.
And just so you know, the draft that you do have under your tab discussion is kind of a mock-up of what you guys have seen that were brought before you. Was basically came from the Assembly rules and the Senate rules, not based off of Robert's rules. So what you have currently set here is mostly Assembly and Senate and committee rules of what this was. So it's specific, a little bit more spelled out and detailed to the State Allocation Board. But the base is for the most part.
But it is a hybrid because it's neither Masons or Roberts.
Yeah.
So to answer Member Fuller's concern, it may function well because of how the drafter sees us, but it is a hybrid. It's neither one. Correct?
So when you go to an arbitrator, unless they have a manual or a training or something that they pass on in perpetuity and they're given that role, how do they be the final guy?
Yeah, they'd have to have a list of the rules and then a default model to know where to default to if there was something that wasn't covered in the rules.
So the only way that works for me, parroting kind of what Ms. Fuller had to say, is that our hybrid would have to be very small.
Yeah.
For very unique circumstances if we do it at all. And then we do have a fallback which is more universally acceptable. Otherwise, I'm kind of in her camp. Given the nature of the change, without continuity somewhere, and I don't know who that person would be unless we hire a parliamentarian and use that person over and over and over again. And I'm not sure we want to bear that expense, or we should bear that expense.
Right, that's okay.
So as a result, I think your point about turnover needs to be factored in.
Well, I just think we're back to like two questions, and I think this is good. We're debating obviously there's not necessarily a perfect answer here, but we are laying on the table all the issues that have
There's a motion for that, by the way.
Yeah, that emerged, and of those emotions that emerged, the one for me was who's the final arbitrator, because at the end of the day, I'm the old teacher. I want to look at who's the teacher who's going to tell me, all right, it's this way or it's not that way, and then that's what we do, and if we come up with and I'm not going to call it hybrid, I'm going to say something that is not pure Masons or pure Roberts, then we have to do some kind of job on who that arbitrator is and how they become the authority on that issue so that they are always around for us to accept. And that does probably necessitate some cost. In a school district, that would be your board policy, but I'm not sure that the SAB would have that capacity.
Regulation.
So anyway, that's the only question I'm trying to answer.
Lisa Jones, you've been
is-
here for 30 years.
Lisa Jones, 30 years? When did you start, at 12?
Yeah.
Something like that.
I would say I would pose caution to the subcommittee in doing regulations, because once you start doing regulations on your procedures, you're stuck with them, and it's really kind of hard to change them as you evolve. So I would say, for purposes of of this meeting, please stay away from trying to do regulations on operating procedures.
I would agree with that. So what we're basically trying to do is just adopt our internal regulations, and unless we want to do something that is clearly not in law at the present time, we would not need to do legislation or anything like that.
That would be correct.
One of the things that the board may also consider as they're doing this is to put in their rules and operating procedures that maybe every January this is adopted and, takes a
Like we
board
do
to
in
change,
committees.
as the Senate and Assembly adopt their House operating rules every year, so that it can't change, that it isn't a moving document.
Committee meets once
That's
a
a
year
good
to
idea.
update it.
That's a good idea, yeah.
When you get right down to it, when you review everything that we do in the legislature, there really aren't that many rules
Right.
that you confront on a daily basis. Most of it's simply driven by the formula of legislation, the creation of the file, committees setting their business, the time deadlines that are in the legislative calendar. There's really very little that we fight about in terms of rules.
I wonder if we could, if people have a sense of either Roberts or Masons. Personally, I don't care. I'd be happy to pick one, do default, ask Lisa to see if she needs to update this and have us proceed to vote on it in our next meeting. The one thing I would say is that this is the number of appeals, which are the things that take time, but also some of the issues that have come up around policy in the bonds. And I've had some of them. How do we spend the money for green schools? How do we define seismic, imminent danger of collapse? After discussing that in connection with some appeals, the Division of the State Architect said that there was no definition and they need $200,000 to do a study to get one. Well, if there's no definition, so in many ways we become a zoning adjustments board, which is a very different animal than a legislative body. It's about adjudicating particular cases in a way, and saying, saying whether or not you can override normal procedure in certain cases.
I think we have had to appeal. We have answered some appeals without criteria or feeling
That's
grounded
right.
in our criteria, and as a result of that, then there have been compounding cases that become what you're talking about.
Precedent.
Well, but it's moved from an allocation board to a
Appeals
appeal board, but then the appeals, the last thing you just said, the zoning and the arbitrating of the specific terms of individual cases have then driven precedents that have then driven new meanings and decisions. And I think that's why we're getting uncomfortable as a board, is we're beginning to feel like, if we are ourselves in danger of legislating through board action, and we do not want to be in that position. I don't think any of us want to be in that position.
Okay. I'm wondering, maybe we should move also to comments from the public after we hear from Mr. Burns again, just to see if people have any suggestions. Then, because we should end at 5, I agree with Ms. Fuller. Meetings should begin. But maybe we could direct Ms. Kaplan to review these draft rules that she has in light of either Mason's or Roberts, and send them to us when they're ready, have us look at them, see if there's any, if we would like to adopt them quickly at our next meeting, or whether we would want to amend them in any way.
And then whatever we do, we take them, I would finish, and then we can take to the full board.
Yeah.
before.
Well, actually, I really would like to, and I'm breaking my own rule here because you see I'm going to push us back. I would like us to decide who we want to be the arbitrator. I think the board needs to have a decision, and they need some information on who they're accepting as arbitrator, regardless of what rules they take. I mean, I think that has to be. Is it the Attorney General? Is it our own attorney? Is it, the legislative rules? I think we need to answer that question. And once we've answered that question, then I think we will have the answer to, is it Mason's, is it Roberts, is it someone like our own attorney that we're asking them to review this document and come up with what they think it is. Because the person who we decide is the final arbitrator of all such questions, that's the person that we go to if these rules we don't feel they apply. And until we have that person, I'm not sure that the rules make any difference. If Lisa redoes these rules and we have the next meeting and somebody doesn't like them, we're still stuck with, okay, are we going to ask our own attorney? Are we going to ask Rob? Are we going to ask the chair? Are we going to call over to the legislative office?
But it won't be a matter of liking or not liking the rules once we have rules.
Yeah, but there needs to be a final arbitrator.
Well, then the lawyer would opine on the rules that we've passed.
And that's what we were just saying.
Oh.
Remember our last meeting where none of us particularly agreed with our attorney?
I think
Oh, there we go.
maybe is if the subcommittee recommends, because I think whatever the subcommittee recommends then has to go to the full board for adoption if it's to change from Roberts. But if the subcommittee recommends Mason's, then maybe it should be recommending whether it's possible to have Dotson or Gregory Schmidt. I don't know how it works, or who's an arbitrator on Mason's. Or an expert, or if they decide Robert's rules. I think a third-party, independent, neutral that would understand, whether it's an expert or something like that, or if there's an expert, because I think you're going to have differences if you have, and maybe disagreements whether you use somebody internal, be it a DGS attorney or then ledge counsel. It's going to be in the age-old who decides. So maybe if there is an outside agreed upon party that was an independent, like the AG or something like that, then that may be.
Every time we ask the AG, it costs us.
Yeah.
Let's acknowledge that.
And in the past, when our first chair, it was our chair, not our last chair, but like 3 chairs ago, it was a chair because she'd been there for a really, really long time, and all the rest of us were a little newer than she was, and nobody ever questioned it.
Do we know why the turnover started to happen?
Term limit?
Was it term limits kicking in, or
well, I know
something else?
Jack and Simidian, and Jack left, and Simidian just didn't want to have whatever, wasn't on there again, and
Jean Mullen
left because of term limits. Margat was termed out here, and that was a hard one too. And then we lost the appointee, the lady, Rosaria, because she got in a fight over the expenses and just all kinds of other issues. And there was, again, no arbitrator. So when I looked into her causes, I couldn't figure out how you resolve it with the arbitrator. So anyway, she left, and now our last chair got another job, and our other chair before that got another job. So a combination of more opportunities opening and term limits.
It was my understanding, though, that I thought that the SAB was operating without rules prior to this. That was one of the reasons why we suggested doing this. So I don't know what they arbitrated on, because they weren't operating by a set of rules.
Wait, Lisa,
yeah.
I'm going to be the chair. How about that? Robert. Yeah.
I'm sorry, am I supposed to be
If
called
I may,
on?
I just want everybody to realize that this, although the board has never technically adopted rules, it was always worked on the Senate rules. Senator Leroy Green, who sat on the board for many, many decades, he made it very clear that it would the board would run by Senate rules. And so, although we didn't necessarily adopt them every year, the chair, and at that time we had a seven-member board, and everybody was in agreement to work under Senate rules. And so it's been an unspoken rule, if you will.
So then why do we
Why don't we start there?
Lisa, if I can ask, why then has the statement sort of been made that we operate under Roberts?
Well, I think it's everybody's different interpretation of how they see the board in action. Some meetings, I will say, for the most part, the board is there's been common courtesy. We've been able to get through agendas. The board's been able to make great decisions and move things off the plate, and new things come on. But I think it's all interpretation of everybody out in the audience and how they see the board making decisions. And I'm just giving you a little background.
Okay. Rebecca?
Senator Hancock, if you look at the date on the Roberts rules that you use in the back of your folder,
Yeah.
you'll see that that's dated 2/25/09 at the very bottom. It's the document that you wanted shared with everybody.
Oh, the
And
sort of
it's
synopsis
this
of
one.
Roberts that I asked. Yeah.
Senator, this one?
Yeah.
It's dated 2/25/09 because I came back following the February meeting of the SAB where Mr. Sheehy indicated that we would follow Robert's rules under his reign. And so I printed those out for you and for all the members of the SAB to use at a subsequent meeting.
This one right here. It's just 2 pages. It should be at the very back of the Roberts section.
Yeah.
So as chair, Mr. Sheehy made a preference call.
Okay.
And that makes sense to me, because I don't think I never really, sorry to say, I never really picked up on him saying that about Robert's rules. So, but
We were probably talking.
it only makes sense to me that it was Leroy Green, because that's the first exposure I ever had as a superintendent, sitting in the back room. This went under his, when he was there. So in my mind, that's how everything was always run. I didn't have a name for it. I didn't really know it was Mason's, actually.
Okay. Are there any other comments from the public, just in terms of a suggestion as to which we might pick as a default? Because then I'd like to ask Lisa to go back and redraft according to whatever we pick as default, or say that we're going to operate under Senate rules, Mason's, or Roberts, except as specified, because I do think that makes sense. Every committee, for instance, in the legislature, has slightly different rules. Some people do sign in order. Some people do, bill order, that kind of thing. So that they can vary. And I think if we have it, you could work from that, Lisa, and then we would have something that we could actually mark up.
So if I understand you, I would be willing to meet again after Lisa has found the exceptions that might not work under either Mason's or Roberts or Senate or whatever. that are listed somewhere in here, and then we would discuss those. And then I think that we probably should invite the chair to that meeting, if it sounds like the
Yes.
chair has had the prerogative in the past to either decide Masons or decide Roberts. And we should specifically highlight to her, if someone is smart enough to figure out what we've said out of this whole mess that's been the problem, the 4 problems that we want to solve based on a model that we're picking. And for me, that would be fine as long as each, like I would, as I'm now informed, I would prefer that it would be Masons, and I'm willing to take the Senate. I don't know the difference between the Senate and the Assembly, but the Senate always does something more than the Assembly does. So I would be willing to take that just because I think we have an arbitrator that at least all the legislators
One motion, you don't
are going to
have
agree to, whether they want to or not, they will.
Yeah.
So, and I don't know anybody else in the room that I know that everybody will agree to. So that would be my first suggestion. I don't know if it's better or worse, and I don't know if the
Try
chair
a
would agree.
motion.
Okay, thank you. I would like to make a motion that we adopt, is that what you want me to say? No, that we use Masons to evaluate the draft in here for custom exceptions that we might need, and bring it back as a mock-up
Mock-up.
at the next meeting, and invite the chair to participate in the discussion of that template.
And if we're currently operating under Robert's rules, I'll second that.
Okay. I would, now, I would actually like to make an amendment that we adopt something that we think makes sense before we ask the chair to sit in and look. And the reason is because she is so busy right now with finance and everything else that's on her plate, stirs, purrs. She has a lot.
And just if I can say, I actually keep the chair informed, and so she
Okay.
does see
Yeah,
this.
but-
And
Okay. Now, if I'm allowed to accept her amendment, under whatever rules we're operating at the moment, then I would accept that amendment if we allowed her in the sitting to amend with this again if there's anything in there she doesn't think will work.
Oh, yeah.
Yeah. Right.
Absolutely.
In other words,
Point
it's
of
a working motion.
clarification?
Okay, point of clarification.
Is your Mason's comment based on the Senate version or Mason's in its pure version? Because I heard a preference for the Senate version of Mason's.
At this point, since we are so lucky to have someone from the Senate, and since it has been clarified that in the past the tradition has dictated the Senate, therefore people who have participated in implementation committees far longer than we have are more likely to be more familiar with that. I am defaulting to that. I have to tell you, I have little knowledge about what differences there might be.
But the good news about that is that when we get the draft back, we can really read it. And if any of us want to make changes, particularly in light of the fact that we are not a legislative body as much as we're evolving into an appeals body, and that we need to have rules and procedures and criteria for that. I think we need a way to move forward in casting these rules. So the motion, as the chair heard the motion is that we will operate under Senate rules, which have Mason as a default. And we ask Ms. Kaplan to review the rules and do any redrafting that needs to be done and bring it back to us, and that we will then go over it line by line and hopefully we'll agree with it and we'll be able to pass it.
Or move it to the
agree here and then to the full.
full body.
Yes.
Where's the chair inserted?
Well, one question that I have is if you've agreed kind of Mason's Senate version shall be what you want to recommend, that recommendation, at least as the default, go to the full SAB, because at last month's board meeting you adopted Robert's rules as the default.
I don't mind waiting another month under Roberts, but it's up to you. I'm more worried
I don't
about.
either.
I'm more worried about I just want to know if the chair thinks she can live with what we're going to do, and then we send it on to the board. I don't care what the timeline
If
is.
it's okay, I've been working with the chair, making sure that she is aware of what is coming to this, so that I can, what I'm doing, work with the chair and take her suggestions, and before I bring it back to you. Does that work?
That would be very good.
That would be very good.
Okay. Now, this is Roberts again. and This is something that can be helpful. Does the secretary, and I'm not sure which Lisa we're looking at, read the motion back, because motions evolve. You know how they are. And
From what I understand is the motion is to adopt Mason's via the Senate version, and for me to evaluate the draft based on Mason's and Senate rules, and come back to the full board for discussion, while at the same time bring this and have the discussion with the chair for her input before I come back to you.
So we're going back to the full board, not back to the committee and then to the board.
no, we're coming back to this board.
Oh, well, she
This
said the
committee.
full board.
This committee. and-
Committee.
After the mock-up is done,
Okay,
after-
with input from the
Right.
chair.
right.
Yeah.
And
Okay.
the only thing I would change about this is the way the senator said it was, and I think it's more terminology correct, that it's the Senate House rules with the default to the Masons. Is that the correct way to say that?
Yeah.
Yeah,
Senate.
Senate rules. I gotta learn something. I'm gonna be saying this. Get me right now.
Okay.
All right.
So the motion's been moved and seconded, and there will be minutes in which the motion will be written out,
Yes.
right, Lisa? Okay.
I will work with Lisa Jones. The Lisa team will work together.
And we also have the transcript too, so.
Perfect.
We're all covered.
Okay, good. Okay, so we'll take the vote. Chair voting aye.
I,
Hancock aye, Fuller aye, Harvey aye,
I,
Brownlee
Okay,
aye.
so that motion is passed. Good. What I would like to do is suggest some additions that she write in, and also take additions from anybody else on the committee. For example, I think the new rule should specify a yearly update of the rules, as we discussed.
It's under discussion.
Yeah. And I think that they should clearly state rules for a quorum
And I do have that under quorum
and
voting.
on-call or
At the
not.
bottom.
Yeah, so just as you look at the review, to look at that. And then I would say, yeah, a process for appeals.
Some time limit for the audience or some
Oh,
public comment.
yeah, you could
Recommendations.
try recommendation on public comment. Will it be after each item? Will it be 30 minutes in the beginning, where people can raise any items before we've discussed them?
items not on the agenda, I would hope, because you could speak to the item as it comes up on the agenda. So public comment normally is items not on the agenda.
No, I think.
I think we're going to look up and see if there's any applicable thing in the Senate rules or Masons, and then if there's not, you're going to figure out as best you can from the collective experience in here what works and put it for our review at the next meeting.
Yeah. I mean,
Because I have no
actually, it
idea.
might work if we do the committee structure, in which,
I like the policy.
in this case, it would be staff presents the recommendation. It's not a bill.
Right.
And then you have speakers, then you would have public comment,
Right.
right?
That's on the agenda.
Yeah,
Right.
and it's on the agenda, after which time a board member would make a motion.
Right.
Because my interest is in having motions that can clearly be amended or moved, so that, yeah, so we don't have,
but I think public comment at the end of a meeting, at least what I'm accustomed to, and maybe the Senate rules don't include this, but it is a time for members of the public to speak to really any issue they would like to speak to. Board can't deliberate on that or engage in a discussion of any sort, but it is the opportunity for the public to talk to us about anything they want to talk to us about.
Or if you do pick something for action, you have to put it on a
Yeah,
future
and
agenda.
somebody could say something, and I'd say, well, let's discuss this, and I would ask that this be put on an agenda later on so it can be noticed and we can discuss it.
Okay. Okay. So that's what we'll do. I
I have
actually.
one more item that
Yeah.
that crossed my mind. Again, it's funny how you fall back on the things
Yeah.
you're comfortable with, and I'm
Exactly.
thinking about my days on the city council.
We all know Roberts. That's what it is.
Exactly.
We're abandoning it, but we all.
I'd
know.
like us to discuss the value, propriety in this case of having ex parte communication disclosure.
I don't know what that means exactly.
That means private conversations that take place out of the public setting. And all you do in those, what we did at the city council is, if you met with the BIA or you met with the Teachers Association, you simply disclose before the matter that that's who you had met with. The idea is transparency, that the public has the right to know who may have talked with you about the item.
Well, I think we need someone to, as Lisa's looking into that, figure that out, because I think there's, under the 3 different models for dealing with that, you know, one is the Bagley, the one we use, the Bagley,
Keen.
Bagley-Keene, and another is the Brown Act, and I don't know what city council uses, but they may have their own city council policy. But they all have a little different method of specifying how you deal with that. So I would say look it up in Masons and give us feedback on that in the next thing. That's the inclusion issue. Yeah.
But, you know, I think the motion as we passed it actually would allow Lisa to come back with a set of basic operating procedures. And once we get those, I think it's another meaning for appeals process and transparency, exactly what you're raising, ex parte, and what do you do? Because people have endless debates about whether you can't have any at all, or do you just disclose them, or whatever. And that would be more to, and hopefully there'll be fewer appeals, you know, if we get really clear operating procedures here. And then another thing I think is going to take another meeting is actually looking at the binder and having board members get a format that'll help staff recommendations pop out at us and explain the pros and cons. Yes. But neither of that is an operating rule. So if we could keep those 2 things for future agendas and just try to get the basic operating rules nailed down at our next meeting, I think that would be good. If people agree, we could adjourn. But again, I do think we should ask if there's any comments from members of the public, any advice, any.
Thank you.
Name for the record, please.
Lyle Smoot, representing Los Angeles Unified. I also was a prior member of the staff. I was the assistant.
I need you up there on the 29th.
Okay.
Which one, this one?
One
The
of
red
these.
ones, the middle ones, the short ones.
The short one.
Where's the?
This one right there.
Thank you. I functioned as the Assistant Executive Officer for the State Allocation Board for, seemed like about 100 years. It was really only 14. I just want to say that, you know, the board did operate for many years using the Senate rules, and it seemed to work very well. I would ask that you consider your arbiter in this conversation as to who that, or, you know, what agency, who's going to provide that function. It'd be nice to really nail that down so you have a recommendation. I think the rules will help, but speaking from the audience's perspective, it seems like sometimes your current arbiter, the attorney for general services, isn't always independent. Forgive me for saying that, Scott, but that's
I would respectfully disagree. but
That's fine.
We will have our own
I would
opinions.
expect you to.
Would you have a suggestion?
Well, if it turns out that you are in fact using Senate rules,
Yeah.
then the person or unit that interprets the Senate rules would be good. Otherwise, maybe hire your own attorney.
Okay, well, not in times of crisis financially, when we're not funding
No, I
schools.
understand the cost
So we'll have to
ramifications.
think. Yeah.
Thank
yeah.
you very much.
Thank you. Any other comments? If not, we will adjourn the meeting, and we will meet again, certainly no later than a month, Lisa?
I will work on that.
And when the draft is done, I know coordinating all our schedules is hard, but let's try to do it.
That's the first thing
It's a
I'll
good
start
time.
doing is coordinating the schedules, because
a good
that
time.
seems to take the longest.
Yeah. Yeah, 3 o'clock probably is a good time. Maybe Wednesdays when we don't have state allocation boards, but we assume.
I chair the education committee that starts at 1:30 on Wednesdays.
Okay. So it's maybe Tuesdays is better. Okay. Anyway, find a time,
I will
find a
work with
3
staff.
o'clock day when our committees get out, and we'll review, and we'll do it.
Thank
Nice
you.
job, Senator.
Should we move
thank
to
you.
adjourn the meeting?
I'd say go for it.
I
Ms.
move
Brownlee.
to adjourn this subcommittee hearing.
I second it.
Hearing no
Without objection,
objection.
so-
Right.
Thank you.
Okay.
Very nice job.